At 6 a.m., the knock came hard enough to rattle the doorframe. Not rushed, not angry. Certain. I opened the door to a deputy sheriff holding an eviction order. Same-day possession. No discussion. I stepped closer to the paper, already forming the words, "This is a mistake." Because this was my house. Because it had been left to me. Because nothing about this made sense. Then I looked up. Across the street, my parents were standing in silence, watching. Not shocked, not confused, prepared. That was when the meaning of the paperwork finally landed. This wasn't a misunderstanding. It was a plan, designed to remove me before I had time to stop it. At 6 a.m., the knock came hard enough to rattle the doorframe. Not rushed, not angry. Certain. I woke with my heart already ahead of me, the room still dark. Rain tapping against the window in that steady Oregon way that makes time feel heavier. For a moment, I thought it was the wind. Then the knock came again. Measured, deliberate, metal against wood. The kind of sound that doesn't ask if you're home. It assumes you are. I checked the clock. 6:01 a.m. I pulled on a sweatshirt and walked down the hallway without turning on the lights. The house was quiet in the way it always was before dawn, the kind of quiet that feels borrowed. When I reached the front door, the knock came a third time, followed by a calm, male voice. "Sheriff's office." My hands went cold, but my movements didn't change. Panic is loud. I'd learned early that silence buys you seconds. I switched on the porch light and looked through the peephole. A deputy sheriff stood on my steps, rain beating on his jacket, a clipboard tucked under one arm. His patrol car sat at the curb with the lights off, as if he'd decided not to announce himself to the neighborhood. I opened the door with the chain still on. "Ma'am," he said, voice neutral, practiced. "Are you Naomi Prescott?" "Yes. I'm Deputy Reed with the Marion County Sheriff's Office," he said. "I'm here to serve a writ of possession." The words landed unevenly, like they didn't belong together. Possession of what? Of who? "There has to be a mistake," I said. "This is my house." He didn't argue. He didn't apologize. He angled the top page so I could see without stepping outside. My name was printed there in black type, clean and official. "I'm not here to determine ownership," he said. "I'm here to execute a court order." I followed the text down the page, my eyes catching on phrases that felt borrowed from someone else's life. Same-day possession. Unlawful detainer. Then I looked up. Across the street, just beyond the glow of the porch light, a car sat parked at the curb. The engine was off. Inside, two silhouettes watched through the windshield. When my eyes adjusted, I recognized them immediately. My parents. They didn't wave. They didn't step out. They just sat there, still and prepared, as if they'd arrived early for something they didn't want to miss. Something inside me went very quiet. "Who filed this?" I asked. Deputy Reed glanced at the paperwork, then back at me. "It was filed by Judith Prescott and Edward Prescott." My mother leaned forward in the car, her face catching the light for a second. She smiled, not warmly, not kindly, but with the satisfaction of someone watching a plan reach the stage where it no longer needs explanation. "When was this entered?" I asked. "Judgment was entered last week," he said. "Last week." I'd been here last week. I'd gone to work, come home, made dinner, slept in my bed. No notices, no warnings, no papers taped to the door. "I was never served," I said. "Where was I served?" He scanned the page again. Service address listed as 42 Harbor Lane. I felt my jaw tighten. Harbor Lane wasn't my address. It was the small rental my parents lived in years ago, before they moved inland. A place I hadn't lived in since college. "That's not where I live," I said. "It's what's on the return of service," he replied carefully. From the car, my mother lowered the window. "We tried to talk to you," she called out, rain softening her voice just enough to sound reasonable. "You wouldn't listen," my father added. "We had to protect what's ours." I didn't look at them. I looked at the deputy. "Can you show me the return of service?" I asked. He flipped back a page and angled it toward me. One line stood out immediately. "Substitute service accepted by adult female occupant." Adult female occupant. The phrase was almost elegant in how thoroughly it erased me. I understood then what this really was. This wasn't about rent. It wasn't about misunderstanding. It was a rush job, designed to move faster than my ability to respond, to remove me from the house before I could gather proof, before I could slow anything down. "Do you have somewhere you can go?" Deputy Reed asked. Procedural. Not unkind. "I'm not going anywhere," I said. "Not yet." He nodded once. "I need to tell you," he said quietly. "This writ authorizes same-day possession." Same day. The words settled in my chest like weight. I didn't argue. I didn't raise my voice. I asked him to hold the paperwork steady while I took clear photos of every page, the case number, the court seal, the service address. Then I stepped back inside, closed the door gently, and slid the deadbolt into place. It wouldn't stop what was coming, but it gave me the only thing that mattered. Time to build a record before they ran out of patience. The door closed behind me with a soft click that felt completely disconnected from what had just entered my life. I stood there for a second longer than necessary, hand still on the deadbolt, listening to the rain outside and the low murmur of my parents' voices drifting through the glass. They weren't arguing. They weren't panicking. They were calm. That was what made it worse. I moved away from the door and into the kitchen, forcing myself to stay deliberate. Fast movements invite mistakes. I pulled the fireproof pouch from the drawer beneath the sink and placed it on the table. Inside were the things my grandfather used to call boring but powerful. The deed, the probate distribution letter, property tax statements in my name, insurance paperwork, proof that didn't raise its voice. I laid everything out in a neat line and took photos, one by one, making sure the dates were visible. Outside, the rain intensified, tapping harder against the windows as if the morning itself were impatient. My phone buzzed while I dialed the courthouse. "Civil Division," a woman answered, voice clipped and efficient. "I have a writ of possession being executed today," I said. I kept my tone level. "I was never served. I need to know how to request an emergency stay and vacate a default judgment." There was a pause. Typing, a longer pause. "What's the case number?" she asked. I read it off from the photo I'd taken at the door. More typing. "This is an unlawful detainer filed by Judith and Edward Prescott," she said. "Default judgment entered last week." "I wasn't served," I repeated. "The service address is incorrect." Another pause. "It says substitute service accepted by an adult female occupant." "That would be my mother," I said, "at an address I don't live at." Her voice shifted. Not into sympathy, but into something closer to attention. "You need to come to the courthouse as soon as we open. Bring identification, proof of your address, and proof of ownership. You'll need to file an emergency motion." "What happens if I don't?" I asked. She exhaled quietly. "If the writ is executed, it becomes harder." Harder, the word systems use when they mean irreversible. "I'm on my way," I said, and ended the call. I opened the front door again, leaving the chain on. Deputy Reed was still standing there, rain darkening the shoulders of his jacket. My parents were still in the car, watching. "I'm going to the courthouse," I told him. "I'm filing an emergency stay." "That's what you should do," he said. Then, lowering his voice, "If you get the order, call our civil unit immediately." "Can you give me the number?" I asked. He hesitated, then wrote it on a small card and slid it through the gap. "I can't give legal advice," he said, "but I can tell you where to send it." From the car, my father finally raised his voice. "Pack your things, Naomi. Don't make this harder than it has to be." I met his eyes through the rain. "You made it hard when you lied to a judge." My mother leaned out the window. "You can file whatever you want," she said. "This is already done." I closed the door without answering. I didn't leave through the front. I went out the back, cut along the side yard, and reached my car without passing them. As I drove away, the street looked unchanged. Same houses, same wet pavement, same quiet. It was unsettling how easily the world ignored a crisis it wasn't personally assigned. At the courthouse, the doors opened to fluorescent light and the smell of disinfectant. I moved through security faster than most people realized what they were waiting for. When I set the paperwork on the tray and said, "I have an eviction being executed today," the guard waved me through without comment. Upstairs, the civil division counter was already forming a line. People clutched folders like flotation devices. When it was my turn, I slid my ID and the photos across the counter. "I need an emergency stay and a motion to vacate," I said. I was never served. The clerk typed, frowned, then turned his monitor slightly toward me. The proof of service filled the screen. My stomach tightened. The signature on the line was neat, deliberate. "Judith Prescott." "She signed for it," I said quietly. "She's the plaintiff." The clerk's eyebrows lifted just a fraction. He printed the page and slid it under the glass. "Highlight that," he said. "It matters." I handed him the deed and probate letter. He scanned them, then clicked again. Faster this time. "Your parents filed this as landlords," he said. "They're claiming you're a tenant holding over." "A tenant?" I repeated. He pulled up another exhibit, a one-page rental agreement. My name typed at the top. Their names listed as landlords. At the bottom, a signature that looked like someone had tried to remember mine and lost patience halfway through. "They forged it," I said. He didn't argue. Clerks rarely do. Instead, he slid a thick packet through the slot. "If you want a judge to see this today," he said, "file your emergency motion now. Department 7. I took the packet and found an empty bench. I filled out the forms slowly, deliberately, every line steady. Wrong address. Plaintiff accepted service. Forged lease. Recorded ownership in my name. When I handed the packet to the courtroom assistant, she read the first page, then the second. Her eyes stopped. "You're saying the plaintiff accepted service on behalf of the defendant?" she asked. "Yes," I said. She disappeared through the door without another word. I sat back on the bench, hands folded, breathing evenly. Somewhere, a clock was still moving toward noon. But for the first time since dawn, it wasn't moving faster than me. The hallway outside Department 7 felt narrower than the others, as if the building itself were applying pressure. Fluorescent lights hummed overhead. A clock ticked too loudly. I sat on the wooden bench with my folder resting against my leg, my foot flat on the floor, my posture controlled. Control was the only thing I still owned completely. People passed without looking at me for more than a second. Attorneys murmured into phones. A clerk hurried by with a stack of files. Everyone here had a reason to be moving. I was waiting. And waiting is where fear tries to grow if you let it. I didn't. The courtroom assistant returned sooner than I expected. She didn't sit down or call my name. She leaned slightly toward the counter and lowered her voice. "Judge Ortega will see you," she said, "but there's something you need to know first." My chest tightened. I nodded. "There's another document attached to your parents' filing," she continued. "It wasn't part of the eviction packet." "What document?" I asked. "A quitclaim deed," she said, "recorded 2 weeks ago. It claims you transferred ownership of the property back to your parents." For a moment, the sounds of the hallway blurred into a low, distant noise. A deed wasn't just another piece of paper. It didn't argue. It didn't threaten. It declared. "I didn't sign anything," I said. She watched me carefully. Not for panic, but for collapse. When neither came, she nodded. "You'll be able to address it?" she said. "I wanted you to hear it before you saw it." Prepared. That was the word she didn't say, but meant. I thanked her and followed her into the courtroom. It was smaller than I expected, darker too, as if designed to make people speak carefully. A few attorneys sat scattered in the benches. When the bailiff called the case number, my parents stood immediately, confident in a way that suggested rehearsal. They were seated at the front table with their attorney between them. My mother wore a neutral sweater and a concerned expression, the kind she used when she wanted to look reasonable to strangers. My father stared straight ahead, jaw set, hands folded. They didn't look surprised to see me alone. Judge Samuel Ortega took the bench and looked down at the file. His eyes paused for just a fraction of a second longer than necessary. "Good morning," he said. We're here on an emergency motion to stay enforcement of a writ of possession. Ms. Prescott, you're the defendant? Yes, Your Honor. And you're appearing without counsel? Yes. He turned to the other table. Counsel? Linda Fraser for the plaintiffs. The attorney replied smoothly. Judge Ortega nodded and returned his attention to me. Ms. Prescott, you understand the writ authorizes same-day possession. Yes, I said. By noon? He didn't acknowledge the urgency. Judges rarely do. Tell me why I should issue a stay. I stepped forward and placed my packet on the clerk's desk. I was never properly served, I said. The proof of service shows the plaintiff accepted substitute service at an address I do not live at. Judge Ortega's gaze sharpened slightly. The plaintiff signed the service form? Yes. Ms. Fraser stood. Your Honor, substitute service is permitted? Answer the question, Judge Ortega said calmly. Did your client sign as the adult occupant who accepted service? There was a pause. Small, noticeable. Yes, Ms. Fraser said, at what was believed to be the defendant's last known address. Judge Ortega looked at me. Is that your last known address? No, I replied. I haven't lived there in years. I handed over my ID and a recent utility bill. He reviewed them, then looked directly at my mother. Mrs. Prescott, he said, why did you accept service on behalf of the defendant at an address that is not her residence? My mother clasped her hands. Your Honor, we were concerned. Naomi had stopped responding. We were trying to protect the property. That's not an answer, Judge Ortega said evenly. You either knew where she lived or you didn't. My father leaned forward. She's been unstable, he said. We didn't know what else to do. The word hung in the room, strategic, deliberate. Judge Ortega didn't react to it. Protect it from whom? He asked. No one answered. Ms. Fraser tried to recover. Your Honor, the plaintiffs are the rightful owners. Judge Ortega lifted a document from the file. One of the exhibits is a deed, he said. A quitclaim deed recorded 2 weeks ago. He looked directly at me. Ms. Prescott, did you sign a deed transferring this property to your parents? No, I said. I did not. You're alleging the deed is fraudulent? Yes, Your Honor, and I can prove I wasn't present for any notarization. How? He asked. I was at work all day, I said. My employer has badge access logs and parking gate records with timestamps. Judge Ortega leaned back slightly. I am not comfortable enforcing a writ of possession on this record, he said. Miss Fraser opened her mouth. He raised a hand. I'm issuing an emergency stay, he said. Effective immediately. Enforcement is suspended pending further review. The words landed cleanly, final enough to breathe. He looked at my parents. If this deed is fraudulent, he said, this court will address it. I exhaled slowly, carefully. Outside the courtroom, the clock was still moving toward noon. But for the first time that morning, it wasn't ahead of me. The hearing ended the way most things do in court. Without drama. No raised voices. No final speeches. Just the clerk calling the next case and people standing as if nothing important had just been paused. But something had been paused. And I could feel it in my chest. Like the pressure had shifted just enough to let air back in. The clerk handed me a copy of the signed order. Emergency stay granted. The words were precise. Temporary, conditional. I read them twice anyway. My parents didn't look at me as they gathered their things. Their attorney leaned in close, speaking in a voice meant only for them. Whatever certainty they'd walked in with hadn't disappeared, but it had cracked. And cracks are where records get in. I didn't wait to see what they would do next. I left the courtroom immediately, moving with purpose instead of relief. Time was still a factor. I just had more of it than I did an hour ago. In the hallway, I pulled out my phone and called the number Deputy Reed had given me. Sheriff's Civil Unit, a dispatcher answered. My name is Naomi Prescott, I said. I have an emergency stay order issued this morning. I need to confirm enforcement is suspended. Typing. A pause. Yes, ma'am, she said. The writ is on hold. Thank you, I replied, and ended the call before anything in my voice could change. Outside, the rain had eased into a fine mist. The courthouse steps were crowded with people who had no idea how close my life had come to being boxed up and removed before noon. Sunlight broke through the clouds in thin streaks, hitting the wet pavement like nothing had happened. I didn't go home. I drove straight to the county recorder's office. The waiting room was quiet in the way administrative spaces always are. No urgency, no emotion, just people holding documents that mattered deeply to them and not at all to anyone else. I took a number and sat down, replaying one sentence in my mind. A quitclaim deed, recorded 2 weeks ago. When my number was called, I stepped up to the counter and slid my ID across along with 2 documents: the probate distribution deed in my name and the quitclaim deed my parents had filed. I need to place a fraud alert on my property record, I said. A judge issued a stay today and raised concerns about this deed. The clerk typed, her eyes scanning the screen. This quitclaim was recorded in person, she said. 2 weeks ago. I didn't sign it, I replied, and I wasn't present for any notarization. She nodded once and printed a form. This won't invalidate the deed, she said, but it will flag the parcel. Anyone pulling the record will see the dispute. That was exactly what I wanted. I signed the form slowly, deliberately, using the same signature I'd used on everything else in my life. She stamped it and added it to the file. Then she hesitated. Can I show you something? She asked. Yes. She turned the monitor slightly. The notary block on the quitclaim deed filled the screen. 1 digit in the commission number had been crossed out and rewritten, small enough to miss if you weren't trained to look. That correction should have triggered a rejection, she said quietly, but it didn't. I felt the shift immediately, not fear, but focus. Can you print that image? I asked. And the intake notes. She did without comment. When she handed me the pages, they were warm from the printer and heavy with implication. When I got home, my parents' car was parked across the street. They weren't inside the house. They weren't knocking. They were waiting. Close enough to remind me they hadn't accepted anything yet. I didn't acknowledge them. I unlocked the door, stepped inside, and locked it again behind me. The house felt alert, not threatened, watchful. I laid the recorder's receipt and the printed images on the kitchen table and photographed them with the timestamp visible. Then I made the call I'd been holding back. Security, a man answered. This is Naomi Prescott, I said. I need badge access logs from 2 weeks ago, specifically the entire day of the 13th. There was a pause. What's the reason? A deed was filed claiming I signed it in front of a notary that day, I said. I need to document where I was. The tone changed immediately. Understood, he said. We'll pull badge entries, parking gate logs, and preserve camera footage. Thank you, I said. The doorbell rang minutes later. I didn't move toward it. I moved toward my phone and started recording, capturing the time, the sound, the quiet before I spoke. Naomi, my mother called through the door. We need to talk. No, I replied. We don't. You're taking this too far, my father said. You took it to court, I said evenly. Communication goes through attorneys now. Silence followed. Then footsteps. A car door. An engine pulling away. Later that evening, an email arrived from security. Logs attached, footage preserved. I stacked the documents neatly, one on top of the other, like bricks set into place. They had tried to move faster than I could think. Instead, they'd forced me to slow down. And slowing down was where the truth started winning. The night after the stay order was quiet in a way that didn't feel peaceful yet. It felt provisional, like the house itself was holding its breath, waiting to see whether the truth would be allowed to finish speaking. I didn't sleep much. I didn't need to. By midnight, I had spread every document across the kitchen table and begun arranging them again, not by category, but by time. When things get dangerous, sequence matters more than sentiment. Eviction filing, proof of service, forged lease, quitclaim deed, recorder's intake sheet, notary commission image, security logs request confirmation. A story told in order is harder to interrupt. Just after 1 in the morning, my phone buzzed. Unknown number. I didn't answer. A text followed. You don't understand what you've started. I stared at the screen until the words lost their shape. Then I screenshotted it, saved it, and forwarded it to myself with the subject line, "Post-stay contact, 1:07 a.m." No response. Responses invite escalation. Records invite accountability. At dawn, I made coffee and watched the street from the kitchen window. My parents' car wasn't there. No shadows lingered. No one pretended to check their phone at the curb. It was just a normal morning again. Birds, damp pavement, a delivery truck down the block. Normalcy can be deceptive. I didn't let it soften me. At work, my badge beeped at the gate exactly the way it always had. I parked, rode the elevator, answered emails. At 9:43 a.m., a message arrived from security with attachments. Badge access logs attached, parking gate entries attached, camera footage preserved. I opened the files slowly. The timestamps were clean, continuous. I hadn't left the building all day on the 13th. No gaps, no room for imagination. Truth doesn't argue. It just occupies space. That afternoon, the recorder's office emailed confirmation. The fraud alert was active and visible on the parcel record. Any attempt to record additional documents would trigger manual review and notification. I closed the laptop and leaned back in my chair. For the first time since the knock, the system was no longer chasing me. It was catching up to them. By evening, my parents tried again, this time with silence shaped like concern. An email from my mother, subject line blank. "We never wanted to hurt you. This has gone too far. Family matters shouldn't be handled like this." I read it once, then again, slowly. The words were carefully chosen, as if responsibility could be diluted by tone. I archived it, forwarded it to myself, and added it to the folder. I didn't reply. Later that night, a car slowed in front of the house and kept moving. I didn't check the camera feed. I didn't need to. Visibility works both ways when you've stopped hiding. Before bed, I installed a small porch camera, clearly visible, no attempt to disguise it. A quiet boundary, the kind that doesn't explain itself. The next morning, I went back to the courthouse, not because I was summoned, but because momentum matters. I filed a request for a temporary restraining order, attaching the voicemail, the late-night text, and a short declaration listing dates and times. No adjectives, no conclusions, just evidence arranged so it couldn't be misunderstood. The clerk reviewed the filing and nodded. "You've been consistent," she said. "I plan to stay that way," I replied. A hearing date was set for the following week. Outside, the sky had cleared completely. Sunlight hit the courthouse steps in a way that made the building look harmless. Buildings always look harmless after they've done something difficult. When I got home, the house felt different. Not safer yet, but aligned. Like the walls recognized the order I'd brought back with me. I sat on the living room floor and let my back rest against the couch. Not to rest, to arrive. There's a moment after people fail to rush you where they try a different tactic. Soft words, delayed threats, appeals to memory. I knew it was coming. I also knew it wouldn't matter. Because once the record is built, it doesn't need your permission to keep moving. If you're still listening to this, you already understand what most people miss. The real turning point isn't court. It's the moment you stop trying to be understood and start trying to be accurate. I didn't win anything that night. I secured something. And what comes next isn't loud, it's procedural, it's patient. The kind of ending that only makes sense if you've stayed long enough to see how quietly the system responds when the facts finally line up. There's more to come, but not because I chased it, because once the truth is written down, it tends to keep going on its own. The restraining order hearing came faster than I expected. Not rushed, just inevitable. Once a record starts moving, it doesn't wait for anyone's comfort. I arrived early and sat in the hallway outside the courtroom, the folder resting on my lap like something with weight and purpose. People passed with coffee cups and whispered conversations, each of them carrying a version of urgency that wasn't mine. Mine had already been distilled into paper. When my parents arrived, they didn't sit near me. Distance had become a rule we all understood now. My mother wore a soft gray coat, neutral enough to suggest reasonableness. My father stood instead of sitting, arms crossed, eyes fixed on the courtroom doors as if staring long enough might change what was inside. The bailiff called the case. We stood. Judge Ortega took the bench and reviewed the file without looking up at first. Silence stretched. The kind that doesn't punish. It measures. "This is a request for a temporary restraining order," he said. "Based on post-stay contact and alleged intimidation." He looked at me. "Ms. Prescott, proceed." I didn't give a speech. I handed over the packet. The voicemail transcript. The late-night text. The email messages sent after the stay was issued. Dates. Times. Screenshots with metadata intact. "I'm not asking the court to interpret intent," I said. "I'm asking the court to acknowledge a pattern." He nodded once and turned to my parents' attorney. "Counsel?" The response was careful. Concern. Misunderstanding. Parental worry framed as urgency. The word family used as if it carried legal weight. Judge Ortega listened without interrupting. Then he asked a single question. "After this court issued a stay and ordered no enforcement, why did your clients continue direct contact with the defendant?" There was no good answer to that. The order was brief. Limited contact. No approaching the property. Communication through counsel only. Temporary. Pending further proceedings. I didn't look at my parents when it was issued. Looking invites commentary. I gathered my papers and walked out as the clerk moved on to the next matter. In the hallway, my mother followed me just far enough to test the boundary. "This is extreme," she said quietly. "You're acting like we're criminals." I stopped, turned just enough so she could hear me clearly. "You filed forged documents in court," I said. "That's not an argument, it's a fact." My father stepped forward. "You think this ends here?" "I think the record decides that," I replied. I left without waiting for a response. Outside, my phone buzzed. A message from the recorder's office confirming the updated status. Disputed deed, flagged. Manual review required for all future filings. An hour later, an email from my employer's legal department. Affidavits prepared. Logs certified. Footage preserved. The system was no longer asking if something was wrong. It was documenting that something had been. Over the next week, the quiet changed again. Not tense. Withdrawn. No emails. No calls. No cars lingering across the street. Silence this time wasn't pressure. It was calculation. Then came the first real consequence. A letter from the Notary Commission office, addressed to me as a listed complainant. The commission was under formal review. The notary had been ordered to surrender her journal and respond to allegations under oath. I placed the letter in the folder and closed it carefully. Not because it was fragile, but because it was finished being mine to handle. 2 days later, another envelope arrived, this one from my parents' attorney. The tone had changed again. No accusations, no warnings. Just a notice. Counsel intends to withdraw. I read it twice, then once more slowly. Withdrawal doesn't mean innocence, it means distance. That evening, I walked through the house room by room, not checking for threats, not looking for damage, reclaiming space, the hallway where the floorboard creaks, the back room that still smells faintly of old books and dust, places that had almost been reduced to inventory. I sat in the living room as the light shifted and thought about something my grandfather used to say when paperwork piled up on the table. "Truth doesn't rush," he'd tell me. "It just waits for the noise to get tired." The noise was tired now. Whatever came next wouldn't be dramatic. It wouldn't need to be. The record was complete enough to move on its own. And for the first time since dawn broke that morning weeks ago, I wasn't bracing for the next knock. I was ready for whatever followed, because it would have to come through the same door as everything else. On the record, the letter from the Notary Commission sat unopened on the counter for most of the morning. Not because I was afraid of what it said, but because I already knew what it meant. Institutions don't ask for journals and sworn responses unless they've seen something they can't ignore. When I finally opened it, the language was formal and exacting. Preliminary findings, duty to cooperate. Failure to appear may result in suspension or revocation. No emotion, no speculation, just procedure lining up behind the truth. I added the letter to the folder and closed it carefully. By midday, another message arrived. This one from the courthouse clerk who had helped me file the restraining order. She didn't include commentary, just an attachment and a short line. For your records. It was a docket update. The judge had issued a referral to the district attorney regarding the deed and the proof of service. Not a decision, not a charge, a referral. The system's way of saying, this no longer belongs to us alone. I sat down at the kitchen table and let that settle. People imagine that moment as relief. It isn't. It's transition. Once something moves out of civil hands and into criminal review, the story stops being personal. You don't drive it anymore. You document and wait. The call from the district attorney's office came 2 days later. Ms. Prescott, the woman said, efficient and calm. We've received a judicial referral concerning a quitclaim deed recorded against your property. We're opening a formal review. I listened without interrupting. We'll need certified copies of your documents, she continued, and a written statement describing your interactions with the parties involved. I can provide that today, I said. I expected you would, she replied. After the call, I didn't move for a moment. The house was quiet, sunlight tracing the edge of the table where the folder rested. For weeks, everything had been about stopping something from happening. Now it was about allowing something to proceed. That afternoon, I prepared the statement. Not long, not dramatic, timeline, facts, attachments referenced by number. I didn't describe how it felt to see my parents across the street that morning. I described where they were standing and at what time. Feelings don't survive cross-examination, details do. I sent the packet by certified mail and email, then archived the confirmations. The next sound to break the quiet was my phone. My father's number. I didn't answer. A voicemail followed. His voice was different this time, lower, controlled in a way that suggested urgency beneath it. This has gone far enough, he said. You're creating consequences that can't be undone. I saved the message, labeled it, forwarded it. 10 minutes later, a text from my mother. We need to talk before this destroys everything. I didn't respond. That evening, a car slowed in front of the house again. Not parked. Just slowed enough to be noticed. I didn't check the camera feed. I didn't step outside. Visibility is only useful if you don't chase it. The next morning, a letter arrived from my parents' attorney. Short, formal, careful. Notice of intent to withdraw as counsel. No explanation, no defense. Just distance being created in writing. I read it once and placed it in the folder. By the end of the week, the consequences were no longer theoretical. The recorder's office updated the parcel record again. Deed subject to investigation. The notary's public profile changed from active to suspended pending review. Small shifts, but irreversible ones. The district attorney's investigator called to confirm receipt of my materials. She asked a few clarifying questions. Dates, locations, whether I had ever authorized my parents to sign on my behalf. No, I said. That's all I needed, she replied. After the call ended, I walked through the house and opened windows that had been shut for weeks. Air moved through rooms that had felt sealed. The house didn't need protection anymore. It needed circulation. That night, I slept without checking the door twice. In the morning, an email arrived from the courthouse. The restraining order was extended without objection. My parents hadn't filed anything in response. Silence, again. But this time, it wasn't pressure. It was retreat. I stood at the front window and watched the street wake up. Neighbors leaving for work. A jogger passing with headphones in. Ordinary life resuming where fear had tried to interrupt it. If you're listening to this and waiting for confrontation, understand something. Most endings don't announce themselves. They thin out. They lose momentum. They stopped showing up. My parents didn't apologize. They didn't explain. They didn't try again. They disappeared from the process the same way they'd tried to remove me, quietly, through paperwork. Only this time, the record wasn't on their side. And once the record moves forward without you, there's nothing left to argue with. Part 8 wouldn't be about defense. It would be about consequences finding their names. The knock never came again. That was how I knew the balance had shifted. Not because someone announced it, but because the pressure simply stopped testing the door. When people believe they still have leverage, they keep trying it. When they don't, they retreat into silence and paperwork. The district attorney's office called the following Monday. This time, the tone was different. Not exploratory, confirmatory. "We've reviewed the materials you submitted," the investigator said. "We've also obtained records from the notary and the recorder's office." I stayed quiet. "There are inconsistencies," she continued, "significant ones. I asked no questions. Investigations move better when you don't try to steer them. We'll need you available if clarification is required," she said. "But at this point, we're proceeding independently." After the call ended, I sat at the kitchen table and let my hands rest flat on the surface. For weeks, everything had depended on me responding quickly enough, making the right call, filing the right motion, saving the right message. Now the weight was no longer centered on my timing. It had transferred. That afternoon, a certified letter arrived from the recorder's office. The disputed quitclaim deed had been formally annotated with a pending fraud investigation notice. Anyone searching the property record would see it immediately. No quiet transfers, no convenient misunderstandings. The house was no longer just protected, it was documented. 2 days later, my employer's legal department forwarded an affidavit they'd finalized: badge access logs, parking gate data, camera timestamps, all authenticated. They asked if I wanted them sent directly to the district attorney. "Yes," I replied. "Please include the case reference." I didn't thank them effusively. Professionals don't need gratitude to do what's right. They need clarity. That evening, my phone buzzed with a text from an unknown number. "If you drop this now, we can still fix it." I stared at the message for a long moment. Then I did exactly what I'd done every other time: screenshot, save, label, forward. No reply. There was nothing left to negotiate. On Friday, the Notary Commission's website updated publicly. Her status was no longer pending. Revoked. I felt no satisfaction reading it. Just confirmation. Notaries aren't punished for mistakes like that. They're removed for choices. The call from my mother came late that night. I didn't answer. The voicemail followed, her voice unsteady in a way I hadn't heard before. "They're asking questions," she said. "You don't know what this could do." I listened once, saved it, added it to the record. What it could do was already doing it. By the end of the week, another letter arrived. This one from my parents' attorney, informing me formally that he no longer represented them in any matter related to the property. No spin, no explanation, just absence. I walked through the house room by room that evening, touching nothing, moving slowly. The floors creaked where they always had. The windows caught the light the same way they always did. The house hadn't changed. What had changed was the way it was defended. When people try to take something from you quickly, it's because they don't want scrutiny. They don't want time. They don't want records. I had given them all three. Standing in the living room, I realized something I hadn't before. I wasn't waiting for resolution anymore. Resolution had already started. What was coming next wasn't for me to manage. It was for the system to finish. And systems, once engaged, don't stop because someone regrets starting them. They stop when they reach an ending. Part 9 would be that ending approaching. Not with noise, not with confrontation, but with consequences stepping forward one document at a time. The call came on a Tuesday afternoon, quiet enough to almost blend into the day. "Ms. Prescott," the woman said, "this is the district attorney's office." I closed my laptop before she finished the sentence. "Some habits become instinct the moment they matter. We're notifying you as the affected party," she continued, that formal charges are being filed. I didn't interrupt. Forgery, filing false instruments, conspiracy related to fraudulent conveyance, she said. You may be contacted again, but your documentation is complete. At this stage, we don't require further action from you. Complete. That word stayed with me after the call ended. Not finished. Complete. Finished implies relief. Complete implies structure. Every piece in place. Within days, the consequences began to surface quietly, the way they always do when the system moves without emotion. The recorder's office issued an updated notice. The quit-claim deed was voided pending adjudication, flagged permanently in the chain of title. Any future transfer would require heightened review and judicial clearance. The house wasn't just returned to me. It was protected from repetition. A week later, a docket alert appeared in my email. My parents' attorney had formally withdrawn from representation. No substitute counsel listed, no new filings, just absence where strategy used to be. Then came the letter, handwritten, folded once, my mother's handwriting, tight, controlled, unmistakable. I hope you're satisfied. I read it slowly, then placed it in the folder with everything else. Not as evidence, as context. People reveal more in handwriting than they ever intend to. My father never wrote. Silence in his case was the clearest admission. The investigator called once more just to confirm a detail, dates, locations, whether I'd ever signed anything voluntarily. No, I said. That aligns with the evidence, she replied. After that, the calls stopped. The street stayed quiet. No parked cars, no slow passes, no attempts to reframe the story. The restraining order remained in effect without challenge. The system had no reason to revisit what was already clear. One evening, I opened the folder and realized something had changed. It was heavy enough now that it didn't bend when I lifted it. Thick with paper, dense with truth. That weight wasn't fear anymore. It was permanence. I walked through the house slowly, not checking locks, not scanning windows, just noticing. The hallway light that flickered slightly before settling, the spot by the back door where my grandfather used to leave his boots, the places that had almost been reduced to line items and inventory. People imagine justice as confrontation. What it really looks like is removal. Removal of access, removal of leverage, removal of the ability to pretend nothing happened. By the time the official notice of charges arrived in the mail, I didn't feel anything sharp. No anger, no triumph. Just confirmation that the story had passed beyond me. That's the moment you know it's real, when the ending no longer needs your voice to carry it. Part 10 wasn't going to be loud. It was going to be final. The final notice arrived without drama, the way endings usually do when they're earned instead of chased. A plain envelope, official seal, language stripped of emotion. The charges were filed. The fraudulent deed was voided. The chain of title was restored. Clean, uninterrupted, corrected in ink that wouldn't fade. I read the letter once, then set it down on the kitchen table and stood there longer than necessary. Not because I needed time to understand it, but because I wanted to feel the absence of urgency. No deadlines, no next steps, no one waiting for a response. Later that afternoon, I went to the county recorder's office one last time. The clerk printed the updated parcel record and slid it across the counter. She didn't smile. She didn't congratulate me. She just nodded, the way people do when something has been handled correctly. Everything's finalized, she said. I nodded back. That was enough. On the drive home, I passed the courthouse without slowing down. Buildings like that don't need acknowledgement once they've finished their work. They don't keep score. They just close files. The house was quiet when I walked in. Sunlight lay across the living room floor exactly where it always had, as if nothing extraordinary had tried to happen here. I sat on the floor with my back against the couch and let the stillness settle without naming it. My parents never contacted me again. No apologies, no explanations, no final attempts to reshape the story. Silence this time wasn't strategy. It was acceptance. The kind that arrives when there's nothing left to negotiate. Weeks later, the district attorney's office confirmed they no longer needed anything from me. The evidence stood on its own. The process would continue without my involvement. That was the real ending. Not the charges, not the paperwork, but the release from participation. I didn't dismantle the protections I'd put in place. The porch camera stayed. The folder stayed. Certified copies remained in the fireproof pouch. Not because I expected trouble, but because reality doesn't reset just because you want it to. One evening, I stood in the doorway and watched the street settle into dusk. Neighbors passing, a dog barking somewhere down the block. Ordinary life continuing where fear had tried to interrupt it. That's how you know something is over. People like to imagine justice as a moment, loud, visible, unmistakable. But most of the time, justice is administrative. Its records corrected, access removed, doors that no longer open when someone tries the old handle. I didn't win by being louder. I didn't win by being cruel. I won by being exact, by writing things down when it would have been easier to argue, by saving messages instead of answering them, by trusting timestamps more than promises. Some stories end with reconciliation, some end with revenge. This one ended with boundaries that held. I turned off the lights, locked the door, and let the house settle around me, not as a prize, not as a battlefield, but as what it had always been meant to be. Home. And if stories like this stay with you, the ones where patience outlasts pressure, where silence becomes strategy, where the record speaks louder than manipulation, then you already know why they're worth hearing all the way through. Because the quiet endings don't announce themselves. They simply remain. And sometimes, staying long enough to hear them is how you know you've learned something worth keeping.